Okay, so good morning. And the topics we're going to cover today are going to be 5 different topics. It's a lot, but we're going to cover sort of the highlights of each of these areas. And if it happens that you are interested in more information, you should certainly feel free to reach out to me or Patrick, and we'll be happy to give you more details. It's just sometimes not everybody cares about it. Just is not, each topic may not be as relevant to each client. So we're going to try to hit 5 different topics, and feel free to ask for more details. A little bit about myself. I have been practicing law, like Monica said, since for 23 something years, almost 24 now, since 1999. And my office is over in Los Altos, but I frequently have clients that are around the Bay Area and over in Asia, whether it's Taiwan, Hong Kong, or China. This is just a slide of some of the places and organizations that I belong to, including the local Chamber of Commerce in Los Altos and Los Altos Hills. And that's a picture of the office. In case you come by, you'll know that you're in the right place when you see this building. And I'd also like to introduce to you Patrick, who is next to me. He has been working with me for the last few years while he was in law school, and he recently graduated last year. And he was raised and attended schools locally in Cupertino. So Patrick, do you want to tell a little bit about yourself?
Sorry about that. Someone keeps trying to call the iPad. Yeah, so my name is Patrick. You can call me Pat. So my background is that I graduated from UC Irvine with a BA in business economics. And I recently graduated Cal State for my law degree. Prior to working with Michelle, even starting from as a law student, I also worked for the district attorney's office in the county of Glen. So that's like up north here. It's a bit of a rural state, nice place. And I got my bar license from the state bar this year.
Okay, so a couple of changes that went into effect earlier this year include AB 1033, allowing ADUs to be sold. So as you know, in case people are wondering what an ADU is, it stands for Accessory Dwelling Unit, and it is essentially like an in-law unit or a self-contained unit. It could be attached or detached from the main house. But that's gotten very popular over the years. But because of the housing shortage, then there's been a great need to create ADUs. And at this point, the law has changed so that ADUs could actually be sold separately. And so that's the general premise of the law, is that this was designed to allow for to meet a housing need, and allowing ADUs to be available to be sold separate from the main house. And so we'll talk about some concerns as well, but it used to be, before this law was in place, that there were a lot of restrictions, and it had to be sold to a certain low to moderate income purchaser, had to be recorded as a tenancy in common, and it was zoned for low income housing for 45 years after selling the ADU. But with the new law in place, it no longer has those restrictions. However, that is bringing, anytime a new law comes into place, there's going to be a lot of just different opinions that come out. And so some of the concerns, for instance, about being able to sell ADUs is going to be, for instance, when ADUs are created, they don't have to meet the same level of safety and building standards that a house has. And so that's why there's going to be, from a consumer protection point of view, concern that when ADUs can be sold off, it may not meet that level of safety and building code requirement that a house required to meet. One sec. The second reason that there's a concern with this law is that when there's a financing, when there's a house that's actually being sold with the ADU and the ADU alone is being sold, the problem is that if that house is under a loan, if there's a mortgage, that can trigger a due on sale clause, which means that interest rates moving as high as they are and constantly moving can actually put the principal purchaser at risk of losing the house and go into foreclosure, because once the ADU is sold off, then the whole loan can become due or subject to higher interest rates. And that means that it's violating the initial loan terms, which causes a big problem. The other problem with AB 1033, though, that's causing a lot of the city governments to be reluctant to just open up the floodgates and just allow all ADUs to be sold without any concern, is that there's no requirement for owner occupancy on these ADUs. So whereas the initial concern was to try to reduce the housing need, the problem is that if there's no need for the owner of the ADU to live in that ADU, what happens is that there's a risk that conglomerates like REITs can start purchasing these ADUs, and then it just becomes a huge disaster and mess, right? When you have companies and large organizations that start owning people's back parts of their backyard, that's going to be a big problem. So governments are definitely they're grappling with this issue and how to have some controls. And in terms of just the new owner of the ADU, it's going to be very difficult to qualify for FHA or any type of conventional financing, because these types of units, which are the ADUs, are not subject to the same safety requirements, like I mentioned about the building codes. And so because of that, it's going to be hard to qualify for regular loans. And so that's going to be a challenge. And so the other thing is that SB 9, which we will be talking about, SB 9 has some concerns about maintaining neighborhoods and just you want to preserve the safety of the neighborhood. Unfortunately, with this new law that came into place, there is no protection against neighborhood changes, the same way that SB 9 had tried to maintain. And so because of that, those are some of the concerns with this new law. And as a result, what happens is that there's going to be, it's not going to be as straightforward as just submitting an application to sell. If you had an ADU in one of your properties, to just submit an application and be approved by the city government. They are really trying to figure out how to have some practical elements than just allowing all parts of people's property to be sold to random new purchasers. Okay, so now I did mention something about SB 9. SB 9 came into effect January 1st of 2022. So it's already been 2 years ago, and still there's just been a lot of in terms of implementation and just challenges with the law. It's still unfolding. And so part of what that law allowed was allowing owners to divide their parcel into 2 different parcels of land, and then allowing each primary residence to have an ADU, which would then create 4 units, right? If you have one piece of land, let's say if it's a 5,000 square foot lot, you divide it into 2 different parts, and then each of those parts can have an ADU. That would mean 4 different occupants in that piece of original land. And so it's still, even though the concept is there, it still requires a lot of city approval. There's a lot of resistance from some neighborhoods. They are allowing some to apply for this called the housing element, and for exceptions to be made to different cities, because it does create a lot of concern that even though there is a housing shortage, a lot of the residents in those cities are saying, not in my backyard, right? They have that mentality that even though we're going to try to solve this housing issue, we don't want our neighborhood to be changed to high density suddenly. Now, the next thing to talk about is going to be Proposition 19. That came into effect almost like 3 years ago. And so the reason why it's still on the table is just it's the same theme that even when new laws come into effect, there's going to be a lot of people who are upset. And it had narrowly passed this law when it was presented on the ballot. It just passed by 51%. So it's very controversial. And there's different elements of Prop 19. The part that I will be talking about is the part that a lot of my clients come to me and talk about, which is what happens, when a parent passes away and they want to leave, and because the cost of housing is so high in the Bay Area, they want to be able to pass that residence to their children and still maintain the low property tax that they had during their lifetime. But before we get into the details of, Prop 19, and I don't want to take everybody's time to talk about, Prop 19, the focus is to really talk about why there are efforts now to try to repeal it and be presented on this year's November election ballot. But I'm going to have Patrick step in now to talk about how Prop 19 had changed from Prop 13. And so a little bit of the background.
Thanks, Michelle. So this is a question that I would get surprisingly often, which is weird because I haven't even been practicing this long yet. I have already been asked this multiple times, right? So they will always ask, what has changed because Prop 19 is passed? And they usually ask this in reference to Prop 13 because they're trying to leave real estate to their children and whatnot, right? So we can go over this. There's basically 4 main requirements that if you own real estate, you want to leave to your kids, that you need to be concerned about from changing from Prop 19 or Prop 13. So the first most important, I would say one of the most important changes is the limited primary residence exclusion. So what did Prop 13 used to do, right? So what it used to do is that if you as the parents have a primary residence and you were going to leave it to your children, you could leave it to them and avoid reassessment altogether, no matter how much the property value had increased during that time. So let's say that I have a kid that I want to leave a house to, right? And let's say when I purchased the house, it was $300,000, and now the house is worth over $2 million. Let's say it's $2 million flat. Under Prop 13, I could leave that house to the child, and it would retain the $300,000 purchase price basis. But because there's a limited primary residence exclusion now of $1 million past the old basis, what this means is because the house started at $300,000, I can only exclude $1 million, right? And $2 million is much larger than that. So with the 1 million plus the base basis, I could only exclude 1.3 million, which means the extra 700,000 would get added on to the new reassessment. So it gets a partial reassessment for anything past $1 million. The second, probably the most important change from Prop 13 to Prop 19 is there's no longer any exclusions allowed for non-primary residence properties. Formerly under Prop 13, the $1 million basis limit applied to non-primary residence properties. So like as in the first example, if I have a house that was purchased for $300,000 that is worth $2 million today, I can leave that property to my child. And I can also leave on, say, a second house. Let's say that it was purchased for $300,000 and it's now worth $1.3 million. I could also pass on the second property to the child and keep that original $300,000 basis because it's within the 1 million exclusion. And then there's 2 other requirements that don't affect the amount that you can leave, but you also need to watch out for. The first one is that there are now faster filing requirements. So under Prop 13, once you wanted to make such a transfer and get the exclusion, you had 3 years to file for the exclusions. Prop 19 has changed it so that you need to make this filing within 1 year of the person receiving the property. The second one is that while it sounds the same, there is actually a stricter residence requirement for Prop 19 as compared to Prop 13. So back when Prop 13 was in effect, the only people that were looked at to qualify for the primary residence is the person trying to transfer the house. So this would be the parents usually, right? Now Prop 19 requires that, let's say, again, I leave a house to my child, that child is now required to, within 1 year of receiving the property, they need to move into the property and use it as their primary residence, or they will not get the exclusion.
So lots to think about. If you needed these, if you need a copy of this PowerPoint, then simply, leave your email with Monica, and we would be happy to share the document, the presentation with you after our webinar today.
Yes.
The next slide is about current efforts to repeal Prop 19. So even when we thought that the law has changed and it will not go backward, there is now, this year, the focus is to try to go backward to where things were before the law passed by 51%. And so it's it's been in place for almost 3 years now. But there's a lot of taxpayers who are very upset about just that their generational wealth. Most people's biggest asset will be their real estate. And if they cannot pass that to their children oftentimes are just unable to stay in the Bay Area and buy real estate. And so if they have to, the children who step in after their parents' passing has to pay a higher amount, the new fair market value of the house. A lot of them have to move out of the area and out of state. And so that has upset a lot of the taxpayer base. And as a result, there is a movement, if you search online for efforts to repeal the Prop 19, it is definitely going on now. And most likely we will be seeing that for vote this November. But, even though we are talking, the focus has also been on just based on taxpayers, owners of the real estate. It's in fact renters, tenants who also benefit from repealing the Prop 19, because anytime reassessments happen upon the generation one passing and then the new one inheriting, if reassessments are going to take place, it's going to cause much higher rents due to the new property taxes, or just have eviction if they can't pay the higher rents due to higher taxes. And so everybody is going to be affected by just higher taxes. And so as a result, there's just a large movement to try to repeal this law that took into effect 3 years ago. And so it's one of those many areas for us to stay tuned. The next thing that I'd like to talk about is that anybody with that owns, and so the new law that has come into place January 1st of this year affects people who own LLCs and corporations, because there's this new disclosure requirement called the Beneficial Ownership Information Report. And the reason for this new law is because a lot of fraud and scams have happened in the past based on just owners, true owners, beneficial owners who are not being disclosed. So they have a series of different entities, and in them, the government doesn't even know. It's not transparent at all. The whole goal for creating those multiple entities was to hide who is the true owner of this of these entities. And that's why the government is tired of that. They're trying to fight back. And as a result, they're requiring everybody who owns an entity to come forward and disclose who is the real owner, the beneficial owner of that entity. And so anybody that owns at least 25% or controls or has substantial control over a company has to come forward and disclose who is the true owner. And this information will not be public knowledge, but it is for all levels of government. So whether it's the federal to the state to the county, everybody will know. There's definitely an obligation to disclose who is the true owner, the true person in control of that entity. And so in terms of when there is this need to comply with this new law, if for instance, the LLC, if it was formed this year, it has 90 days to file this new disclosure requirement. And if it was filed next year for entities coming after, there will be a, going forward, it will be a 30-day turnaround time to disclose so that there's no delay. And so it is an obligation that can be done by the owner themselves. They can either hire a professional like Patrick or myself to file it, but it's also meant for anybody to just create an account and be able to satisfy that new requirement. Now, the next slide is about integrating LLCs into your estate plan. A lot of times, the reason I wanted to talk about this topic is because many of my clients do have limited liability companies, and it's for asset protection. It makes a lot of sense to have an LLC, but then they also have a revocable living trust to avoid probate. So there's two different goals. The LLC is created for asset protection purposes. The trust is created to avoid probate and to minimize taxes. But the problem with these two entities that I often see is that they don't communicate and they're not integrated together. So the problem is that the LLC, when a member of, which we call a member, the owner of the LLC passes away, it's not clear what happens to the LLC. And oftentimes, if it's not clear, it has to go to probate court in order to transfer that membership interest, that ownership interest to the new, to the children or the surviving spouse. And so that is something that is very predictable, that if there's a member, the member at some point will need to transfer that ownership. And so the answer could be in the LLC operating agreement to say that if there's more than one member, if one member passes away, what is the buy-sell provisions in this LLC? But the other thing is that even if you have an LLC agreement and all the members can buy each other's interest, the problem is that at some point that LLC interest should also be tied to the trust, so that the trust, even if it's a fractional ownership, even if the member only has 50% of the LLC, it's important that the trust owns that 50% in order to avoid probate. Otherwise, it just becomes unclear what happens to that owner when they've passed away. Now, if you want more details, it's certainly all of these topics we're just sort of, scratching the surface. If you need more information, we'd be happy to discuss further. Now, the next slide, I'm going to have Patrick discuss.
Hello again. So what I'm going to discuss, I don't have time today to really go in depth into the nitty gritty of how to actually set it up. But this again ties back to Prop 19 and Prop 13 actually, because this has become much more complicated as a result of Prop 19. So as we were talking about earlier, what the major issue with Prop 19 is the limited reassessments for your primary residence, and then the basically no exclusion for reassessments for other real estate that you may own, right? In which if you want to leave it to your kids. So there's actually a way, I refer to this as the LLC series structure. There is a way to structure a series of LLCs that you make transfers to over a pretty long period of time. We're talking like probably 4 or 5 years. But if done properly, you can actually avoid reassessment and full ownership can be transferred completely to your children. But the downsides of this is, again, like I said, it takes multiple years and multiple LLCs to complete, and you need to maintain these LLCs, which probably means you need to hire someone to deal with all the paperwork that an LLC needs to do every year. And it becomes more complex when you don't have 2 or more kids. And I'm going to talk a little bit about why this is, right? So to avoid the reassessment, we're basically taking advantage of there's 2 rules, right? So the first rule is called the legal entity exclusion. So what the legal entity exclusion does is that if you have a legal entity, so in this case, we'll be using an LLC, is that you can transfer exactly 50% of that LLC to a different party, and it will not trigger reassessment of property within the LLC. The moment you transfer more than 1/2, it will trigger a complete reassessment of all the property. The second one we're talking about is a proportional interest exclusion. What this means is that you are allowed to take property in and out of legal entities, or in this case, an LLC, without triggering a reassessment as long as the proportional interest remains the same. So for example, if I were to put a house into an LLC and then I just remove it out of an LLC, just doing that will not trigger a reassessment because all I'm doing it is moving in and out of the legal entity, but the proportional interest does not change because I, this entire time, have still owned either 100% of the LLC or 100% of the property itself. So by taking advantage of these two rules, by using an LLC series structure, you can actually avoid reassessment. Formerly, this actually did not, this was not nearly as complicated and doesn't require you to wait multiple years and use multiple LLCs. And this is actually because of a change caused by Prop 19. So there is a doctrine for that the California courts follow. It's called the step doctrine. What the step doctrine does is it allows the assessor, if they think that you are setting up multiple transactions to specifically to avoid reassessment, they can be allowed to just consider all that one transaction for a series of reassessment and force you to reassess the property. Prior to Prop 19, so when Prop 13 was in effect, it was written into Prop 13 that the assessor's office is allowed to apply the step doctrine other than to transactions involving parents giving their property to their children. So they were expressly prohibited from applying the step doctrine to these such transfers, making it so you wouldn't have to jump through all these hoops to accomplish the same result. But because that language has essentially been removed by Prop 19, it has been reinterpreted by the office and the courts that they are now allowed to apply this doctrine. So whether or not that part gets repealed, if the repeal vote passes in November, we'll have to wait and see.
And that brings us to the end of our presentation. We are happy to stick around and answer questions, though, if you have any.
Yes.
And feel free to reach out to Monica for a copy of these slides, but here is my contact information.
We're going to circulate the recording as well as the PDF file of this presentation to people who have registered. So if you have any question, please type it up in the chat box. But I do have a couple of questions for Michelle and Patrick for now.
Sure.
Yeah, so it's very interesting to learn about how you could use the legal entity to kind of like say evade the possibility of reassessment, provided is say less than 50% transfer. So does it apply to different states in the nation or just California that you mainly implying?
I can't speak for other states other than California because I'm not licensed to practice in any other state but California, and these are based on California codes. So I can't speak for other states. I would do it. I would use a series of California LLCs if you were trying to do this.
I see. So mainly focus on California. So like say if you have an LLC and you can include an LLC in your living trust, you say your revocable trust. But then if you already pass 50% to your kids, say to be one of the say members of the LLC. So if like the owner pass away, would that be kind of like eliminate the possibility for the step up, being that is only the one of the child or children, say you say have at least two, then may not have a step up on the basis. Would that be the case?
Let me figure out. So, are you asking what happens if you have like an LLC and you have a property
so
and half the children, the child owns half of it?
Yeah, so like
one
something that is
clarifying thing
an
I need to
investment,
provide-
not a primary. Yeah.
Yeah. So one thing I need to explain first of all would be that if you're using the series structure, you're not going to be integrating that LLC into the trust. This is going to be basically that the goal is to transfer it before you die. Like that you wouldn't be integrating a series LLC into your living. So the second question would be, so let me clarify, is for a non-primary residence property. Is that your question?
Yeah.
So if you set it up properly with an LLC series, you can avoid reassessment even on non-property. But again, it's going to be, if you like die while you're doing this process, then it'll probably trigger a reassessment. That's again like why it's become more complicated and more of a risk. And one of the things I didn't touch upon, well, since we don't have that much time, but if you haven't purchased your property and your goal is to sort of basically avoid reassessment and it's not a primary residence property, and if you haven't purchased it yet, I would highly recommend you consider when you purchase it, you put it in the name of the LLC when you make the transaction, because there's a different treatment between properties that are owned by an LLC, like from initially through all the way through, and treatment for real estate that is owned by an individual and later transferred into the LLC. So the LLC series is designed specifically for if you purchased a property, put it in your name, and then had to transfer it later. Because that's like, unfortunately, most people are not going to be thinking this far ahead, and they're not going to make an LLC and then just purchase some investment property and just put it in the name, right? Because you get much more favorable treatment if the original owner is an LLC instead of an individual. Because they do realize like what people are trying to do when they transfer individual owned real estate into LLCs.
Well, I think my clients probably need a private consultation on this because it will involve various aspects. You could purchase it in an LLC. Like there would be a few things. You have to set up an LLC in advance. It could be maybe a number of family members to be the members. Like one may be the managing member and the rest would be just a member. But then when you try to do financing, a lot of the lender may not be quite treat the LLC financing as like a conventional financing, unless you're buying a commercial property. And also now, especially in California, we have a lot of insurance issue, and having an LLC also requires commercial insurance. Not to mention that like an LLC every year, there would be a minimum audit fee of $800. But then of course it might have its pro side, being that you can save on the property tax, avoid the reassessment, being that, it would be an entity. So an entity basically in principle does not die. You can always transfer interest. So, but like comparing this pros and cons, maybe need some, legal professional like Michelle and Patrick to explain a bit further. But I just kind of like, I'm curious, being that I work with a lot of clients, some own LLC, some do not, but then I'm sure that they will be comparing the various benefits in forming the LLC. So I have another question, that is already in the chat box, because for details of this discussion, I'll leave it for my attendee to contact Michelle and Patrick. New question. Yeah. The new changes for Prop 19, which are detrimental to homeowners passing on their wealth. Question was that if it changed voted into law by the public, how are these changes being implemented? How can we help to reverse these changes?
Well, it should be on the ballot in November this year. So if you want to revert the changes like I do, right, you would, go to the polls and vote to repeal it. Because it's literally up for vote this November of 2024.
Yeah. So before we start, let me just have a continuous question. So Proposition 19 composed of the 13 and I think the 16. So the other part that is for a Californian owner, 55 plus, they want to downsize. So they have their original primary residence at a lower tax bracket. If they're going to sell it, that proposition would allow them to transfer the tax basis to any part in California instead of like the 3 counties. So I just want to confirm that that part is not in the ballot to be repealed. So far, you do not see that, right?
So far, I do not see that, but I think I would want to double check just to make sure whether that Proposition 16 is part of the effort to repeal it.
Yes.
Yeah, because the part that I talked about today was repealing the reassessment upon death by the parents to the children. So that part has caused a lot of, just a lot of
Well,
resistance.
yeah, definitely agree. Huh. So we have another question from the attendee, Nancy. If I bought a property 2 years ago under her name, do you think it's a good idea to transfer it into an LLC now? Is it the best thing to do?
I mean, what are your goals, right? Like, I can't really answer that question if I don't understand what your goals are. And I would need a lot more information, and I'm not sure I'd be comfortable discussing this in the public with other attendees. Like, and
Yes.
there's no like, you can't just, there's no like easy answer to like, oh, should I put my house in an LLC, right? Like, because again, remember, reassessment is bad because it'll raise your property taxes, right? But if you're immediately selling the house, having that reassessment is actually good because once it's reassessed, because let's say you just pass it normally and it gets stepped up all the way, right? That also means if you sell it, you're not paying capital gains. Like the reassessment, who a reassessment really like screws over are generally people that, let's say, like, it's like, again, let's use me again as an example. Let's say I have a kid that I want to leave the house, right? Like, if the kid's gonna sell the house immediately once I pass it to him at my death, it's actually great that it gets reassessed. It's like there's no gains to be realized on the sale of the capital, the long-term investment pretty much at this point if it gets reassessed, right? What screws him over is that if he decides to live in the house, now he's paying a reassessed property tax, and which is probably going to increase like if I purchased a house like 10 years ago compared to those prices then to those prices now, like you're probably like it's easily going to be over like $10,000 in property taxes. So if the kid wants to live in the house after your passing, you should really like think about what you really want to do. But if they're going to immediately sell it, like the reassessment is probably the best thing that can happen for you.
And I think that is something that is worth just emphasizing, because we didn't talk about that earlier in our discussion. But being able to have the property reset to fair market value, if the goal is if the children don't want to live in the house or keep it for property management, then it is a good thing, because then it does erase the capital gains if they sell it immediately after the parents pass away. So that's why there's a lot of different facets to consider, and it's hard to just give any blanket advice.
If you are interested, do give your contact information for Monica, because down the line, I'm planning to give a presentation that talks more in depth, step by step, for a lot of things that we talked about today. So it'll be mostly about Prop 19 and 13 and the LLC structures and reassessments. We'll go over everything like step by step. We'll do examples, and then you'll be able to see like, oh, why the answer changes depending on what your goal is.
Yeah, so very often we have to set our goal first on what is your purpose, whether you're going to hold it for long term and short term. And also sometimes, regarding tax, we probably also, apart from having the lawyer to give you suggestion, you might also need to contact your CPA if you are trying to do something because you think, hey, I'm going to have the step up, bigger, higher, like bigger assessment and kind of bump up the market price before you sell. Then you probably also want to make sure that, this is something would be optimal to do before you get an audit.
Mm-hmm.
So yeah, that's a good question. I would suggest, any of the attendee who have more detailed question, please reach out to Michelle and Patrick for a private session and discuss about your scenario. And I have further question regarding the ADU. I know that a lot of things is still pretty fluid right now. And I have a number of clients who are very, very strong in trying to build ADU to increase income. So definitely with the 1033 is something that is very exciting, that they might be able to sell it separately and some of the restriction will go away. And however, say the city would still have all the final say, right? Being that say if you have an ADU at the back, then the city probably have to evaluate whether you would have the zoning,
Mhm.
like enough parking spaces to support it, and whether you have like separate water meter, separate electrical meter, separate sewage, and all those to allow that it can be really be sold as a separate unit. Does the law include anything about like the city would have all this the final decision on what to approve and not to approve, right?
Well, yeah, sure. So I guess I can talk about this a little bit. So I guess it would make more sense. Let me. I need to talk about the background a little bit, just because it makes sense in the context, right? So the idea of selling like half of your property as already exists under SB9, right? So, but there's actually a great study done again by my alma mater, Berkeley, right? So they took a look at how many actual applications for lot splits and like were filed in like 13 different cities, and how many were actually approved and all that. And what the consensus basically comes out is like there's not very many people that are filing these the SB9 lot split requests, and even the ones that are like the applications that are filed, there's not very many that get accepted, right? So like there's a number of reasons why this is the case. Like first, it could just be people just consider it like there's too much work, it's too involved, right? But the more realistic answer, I think, because this is reflected in the cities that had more than the average percentage that were accepted, right? If you look at certain cities, even if we say like, oh, you're allowed to split your lot, but at the end of the day, it still has to comport with certain safety standards, building codes, and that type of stuff, right? There's just not very many cities that have lots like current parcels that it's actually that viable to like cut the lot in half. Like that, it's just not like most cities just don't have lots that are big enough for this, right? So what does this mean? Like, why is this ADU like being able to be sold to anyone now? Like, why is this being pushed, right? So the idea of the ADU is in the first part, important part that a lot of people do forget is technically the ADU, it doesn't need to be like a 50-50 split down the line, right? The ADU has, if the last I looked into it, is about like, I think it was like 800 square foot. You can have up to like 2 floors, depending on where you are. But the lot that way doesn't have to be split 50-50. It's not nearly as strict as it was with under SB9. And the second thing is now that the ADUs, since they're also smaller, it's easier to accommodate, right? So I like that's where they're trying to push this, like why they're going for this.
Yeah. So like the lot and parcel depends on the city, depends on the
Yes.
size, and
Yeah.
also very often it depends on the parking space. Because
Yeah.
like of course existing neighbors, they really, you know, are concerned about like traffic and all those issues. And also when you build an ADU, you know, we have many clients who build ADU, whether they have all the separate amenities being in place, because sometimes when you have to put in a separate water meter or separate sewage, separate electrical, unless you really gear for it. Sometimes, you know, people do not build in all this when they try to have the initial ADU. But whether it can be approved for sale, I think probably the city have to really set up some rules, you know,
Yes.
before, yeah, like
Yeah. At the end of the
time to
day,
do
like
that.
the state can, like the state has been, California has been moving in this direction for like a long time at this point. They're basically trying to cut down on as many reasons why the city can say no, right? Because they see all these applications that are being filed or not being filed, and they see the low percentage that actually get passed. And there's been a lot of like blame that has been put on like the cities and residents. That it's like, oh, there's just a bunch of NIMBYs in my like in the city, like not in my backyard, right? Or it's just the city doesn't want to accommodate lower income housing. But like the truth of the reality is like the lots as they are right now, like a lot of them just it's not viable to accommodate many of these smaller units. Like being able to sell your ADU is going to be easier than being able to basically like try to like split your lot under SB9 and have 2 lots and like sell like that. But I would be cautiously optimistic, I guess, is the way to put it. Don't put all your eggs in this basket because it may not have that big of an impact as you would think. Just because it's like, oh, the state says you can now do this, build your ADU and sell it. it's still going to come down to the fact that like the city needs to check that it's actually safe and viable for you to do. Like at the end of the day, no matter what law they pass, like they can't, like the city will always have the final say unless they basically just like rezone the entire city, which there's no way that's going to happen pretty much.
Yeah, I think it's hard.
Yeah.
Being in this business for a long time. Yeah, they have so many existing housing, unless you have like recently we done something is like we've seen like houses say in Morgan Hill, they are on a 10-acre lot.
Mhm.
And they have like 2 old houses on it and still on septic tank. And then that's easier because they have enough, like space to kind of subdivide and
Yeah.
they put in additional houses on it and keep some of the existing. But then if you only have like, say, even you have like 8,000, 10,000, the ingress and egress may not be very easy unless you're on a
Mhm.
corner lot. And then also, like I said, the ADU, whether it's fully equipped to be independent. But of
Yeah.
course, from the state point of view, if more housing they sell, more housing needs can be made, and also they have like, maybe more property tax income. That's
Mhm.
very different perspective. So I
Yeah.
think, yeah, just being the owner, they have to be cautiously optimistic in terms of finding out all the facts before you say, hey, let's build more ADU because you can sell it separately.
Yeah.
Right.
Yeah,
I
it
think
really depends on a lot of physical environment.
Monica, you mentioned your clients are interested in building the ADU. It's still a great reason, like even if you can't sell the ADU separately, it's still a great addition to have as part of the house though. So I think it's still a great investment, but not with the expectation of being able to sell it separately. If they sell their house and it has an ADU, I think that's always an excellent feature that people are looking for.
Yeah, definitely. And so I have a lot of clients, but of course, like the high labor costs, material costs, and building an ADU, I have heard people like they spend about 600K just to build 1,000 square feet ADU. And also depends on location. So there are many factors for you to make a decision if you're proceeding with your ADU construction. But then right now, as we can see, more and more cities are more flexible. Recently I just actually closed on a sale that is an older home in East Palo Alto, and it's a small lot. It's a small house, but then 6,800 square feet lot. And I was very surprised to learn from the city of Palo Alto that they can East Palo Alto that they can allow to build a 5-story apartment on a 6,800 square feet lot. So I was very, very amazed that city is very progressive and trying to increase housing. And the planner actually called me back and said, if it is for affordable housing, can even build more.
Yeah, because the cities are actually under pressure from the state to actually meet a certain amount of housing. They have to increase housing, so they have to figure out how they're going to make it happen in order to comply with the state requirement.
Yes, yeah, I totally agree. So I think there's a lot of opportunities for California homeowners or investors. And now being that like the state is more lenient, but at the same time, we understand everything is going up, property tax and insurance in particular. And now, for the people who are on the call today, insurance can become a contingency when you purchase a house because it's not very easy to find insurance even if you got in contract for a new home, because a lot of companies are leaving California.
Pulling out, that's right.
Mhm.
It's very
Yeah,
difficult.
it's very challenging. Yeah, I have like some of the small home that we got into contract that they're asking, it's only 1,300 square feet, and then the insurance quote is $4,400.
It
So
is very unfortunate. It is.
yeah, it is kind of like say surprising to us.
Yeah.
So, but anyway, if you do have other questions, being that I don't see any other question in the chat box, we welcome you to contact Michelle and Patrick for your private questions. And I've been to Michelle's office, very convenient, it's in Los Altos, and they are very reachable. And so like, we hope you think this webinar is very useful because it's a lot of good information. And any other thing, Michelle, you want to say to us before we round it up?
No, I think there's so much to discuss. And like Patrick said, he has a separate presentation that he prepared just focusing on that Prop 19 and the series LLC structure on how the nuts and bolts of it would work. So if some attendees actually want to find out more, that is something that you'll want to reach out to our office and make sure that we invite you when that presentation is available. And if anybody is just wants to, the link on this screen that we have in front of us at the bottom, there is a link, and that link allows you to set up a Zoom meeting with me. So if you are able to come in person, that's always nice, but otherwise a Zoom meeting is also possible by clicking on that link and then setting up an appointment to find out specifically just what your needs are and what you're looking for, because it's very hard to address in a general conversation. And of course, that disclaimer that we always say as lawyers is just that nothing that we talked about is legal advice, and that it really is, you really need to come and speak to a professional to understand what is most appropriate for your situation.
Yes, so I encourage everybody to take a photo of that screen if you want to reach out to Michelle and Patrick after this event, and then set up a Zoom meeting. And I think that would be the most useful way to do. Again, thank you very much. Yes,
My pleasure.
a great event, a lot of information together, and then a lot of things to digest. And I would be reaching out to Patrick about the details of his Proposition 19 study. Maybe we could also provide an opportunity for my audience to learn about it more. Okay.
Sounds good.
Thank you, Monica, for
thank you very much. Have a good rest of the weekend. Thank you, everybody, for attending. Thank you.
Bye.
Bye.
Bye-bye.